What is representative suit?
Sir, namaskar. Representative
Namaskar.
suit means the suit which is filed by one or more persons on behalf of a person, and it is filed by one or more persons with same interest in the suit. It is explained under Order 1, Rule 8 of the Civil Procedure Code.
What is the procedure to be followed for instituting a representative suit?
The procedure which is to be followed for instituting representative suit is if one or more persons is having same interest in a particular case, they can file a representative. One person on behalf of other persons can file a representative suit. They can take the permission of the court and give advertisement. By giving advertisement in the newspaper, or personal notice can be served. Then after that then the thing will be binding on the person.
When a plaint is to be amended,
The plaint is to be amended if there is the plaint can be amended if there is some defect in the plaint, if the names of the parties are to be altered, if the cause of action has been altered, then if it is these are the things where plaint can be amended.
what is non-gender of necessary party?
Non-gender of necessary party means if the parties whose presence is essential for the suit, and it will be very fatal if the parties do not join, and as they are having legal interest in the suit, then it is known as a non-gender of necessary party.
Who is a proper party?
Proper party is a person whose presence is not essential in the suit, and he has no legal interest. And if the proper party does not join, it will not be fatal, but it will be beneficial for the suit and for the proceeding, and for the future interest also.
What do you mean by beneficial?
Sir, beneficial means useful, sir.
Okay. Whether court can amend the frame additional issue after argument of the case?
Sir, yes, court can amend the additional issues after the argument if it is found by the court that it could not have been brought to the notice of the court before the settlement of issues, and within due diligence it could not be brought within the notice of the court. Then after argument also the additional issues can be made.
Is there any time restriction for filing amendment of the pleading?
Sorry, sir.
Restriction, is there any restriction for amending the pleading?
Sir, yes, there is a restriction for the amendment of the pleading. The pleading needs to be amended before trial, but if it is found by due diligence that it could not be brought to be noticed due to certain circumstances before trial, then also after a trial also it can be brought to the notice.
A person was, for groundlessly, without any ground, an injunction was issued against a person. Can he claim compensatory cost or any other remedy from the court against the person who brought an injunction against him without any reason?
Yes, sir. If an unjustified ground injunction is issued against a person, then that person can recover compensation from the person who has prayed in before the court to bring the injunction petition. It is also explained under section 95 of the Civil Procedure Code, and the recovery amount should not exceed 50,000.
You have completed LLM perhaps?
Yes, sir.
In which subject?
Sir, I've completed my LLM in International Trade and Investment Law.
What is a promissory note?
Promissory note means it is it is a document where a person promises to pay certain amount on a due date.
What is bill of exchange?
Sorry, sir.
What is check?
So check is a document which is written by a particular person, and it is deposited in the bank in the favor of a particular beneficiary, so that that person can get that amount.
What is right of private defense?
Right of private defense means the it is a right where the person is having to defend oneself and also its property and also others body and others property, and it is explained under section 96 of the uh, Indian Penal Code.
If right of private defense is available against an innocent person,
Yes, sir. Right of private defense is also available against insane person.
what is a suit of civil nature?
Suit of civil nature, it means where the aggrieved party files a plaint with certain issues and cause of action against another party. This is known as a suit of civil nature, and it is explained under section 9 of the CPC.
What is cause of action?
Cause of action means it is a bundle of essential facts which gives rise to plaintiff to file a suit against a defendant on certain cause bundle of essential facts.
What is counterclaim?
Counterclaim, it means the claim which is filed by the defendant against the claim given by the plaintiff. In the plaint that the defendant is not has certain allegations against the plaint, and the defendant is claiming for other certain relief.
What is set off?
Set off means it is where the defendant wants to set off against the plaintiff demands against any a certain sum of money which can be legally recoverable. Then not after the first hearing, but at the first hearing, defendant can claim set off against the plaintiff's demand.
Can a suit be filed against the government dispensing notice under section 80 of the CPC?
Yes, sir. A notice can be filed against government dispensing the notice.
Then in such case, what is the restriction, if any?
Sorry, sir. Presently, I'm not able to recall it.
What is specific relief?
Specific relief means the relief which is extraordinary for a particular person, and it cannot be recoverable by certain damages which the court can award by certain compensation. It is something very special for a particular person, and that particular relief needs to be enforced for that person.
What is attachment before judgment?
Attachment before judgment means the certain properties like if the plaintiff if the person who is wants to abscond from the local jurisdiction and if having an immovable property also that person wants to uh, remove it from the local jurisdiction, then a warrant can be issued by a court, and like the person can give money, and then only warrant will be not issued, and in this way attachment is done before the judgment.
What is the of alternate forum for disposal of a civil case?
The alternate forum for disposal of a civil case can be done through arbitration, conciliation, mediation, and through legal services, Lok Adalat.
What is your view regarding uniform civil code?
Sir, Uniform Civil Code is the present need of the hour because it will end religious discrimination in our country, and it will promote, upheld the secularism concept of our Indian constitution, and it also will provide equal rights to women, and it will provide same set of laws with matters regarding to marriage, adoption, divorce, inheritance, and succession for the all communities in India.
What is the right of a child born through void and voidable marriage?
So the child born through void and voidable marriage can claim the self-acquired property of their parents, but the child cannot claim the is having no right on the ancestral property.
Okay, I will give you the feedback after the second interview by the second panelist.
Good
Good
evening,
evening,
sir. Sir,
Rutuparna.
namaskar.
Namaskar. What is doctrine of double jeopardy?
Doctrine of double jeopardy means no one can be convicted twice in a case.
Is there any distinction between Section 300 of CRPC and Sub-Article 2 of Article 20 of Constitution of India?
Sir, sir, no, there is no such. Yes, there is a difference between Section 300 CRPC and Section 20 Clause 2. Section 300 CRPC explains that if a person it bars subsequent trials if the person has already been tried, and if a person who has been previously tried in a particular jurisdiction, competent jurisdiction, and conviction and acquittal is in force, then that person cannot be tried again. Section 20 clause 2 explains that no one can be tried and no one can be convicted for a case twice.
What is the position of vicarious liability under the criminal law? Can a person be held guilty for commission of an offense which is being committed by another person?
Yes, a person can be held guilty for commission of an offense committed by another person if that person is answerable for the wrongs committed by another person, and if that person has ratified the act of that person, and if that person is the employer and employed the employee for the work, and employee has done the work during the course of employment.
Under which provision of the IPC?
Sorry, sir. Presently, I'm not able to recall it.
Okay. In the absence of mens rea, can an offense be committed?
Sir, in absence of mens rea, no, sir. In absence of mens rea, offense cannot be committed.
Two persons, they have entered into a criminal conspiracy. Entered into a conspiracy. Okay, that will certain do an act which is forbidden by law, but subsequently they could not able to succeed or to perform that act, whether they are liable under the penal provision or not.
So they had made the conspiracy and they had the mens rea to commit the crime. So they are liable under the penal provision.
Under which provision?
Sir, I'm not sure. I think, sir, under section 120B of Indian Penal Code.
What are the differences between appeal and revision under the Code of Criminal Procedure?
Appeal is a creation of statute. It is made on the point of fact and law, but revision is not the creation of statute. Where there is no appeal, there is the provision of revision, and it is only made on the point of law. Then there is no system of second revision, or there is no system of second revision, but there is the system of second appeal. Appeal, yes, sir.
That means you want to say that under the Code of Criminal Procedure there is a provision of second appeal.
Yes, sir.
Okay. Suppose A, being victimized by B, instituted an affair before the concerned police station, and after conclusion of the investigation, the police has submitted the charge sheet before the concerned court. Okay. Whether that complainant has any locus standi to file an application or to approach the court for further investigation.
Sorry, sir, I am not able to answer.
What is an order under Civil Procedure Code?
Order under Civil Procedure Code explains the sections of the Civil Procedure Code, and the this order section deals with order deals with the section, and it explains the sections of the Civil Procedure Code.
What is decree?
Decree is the formal expression of an adjudication which the court, so far as regards the rights of the which the court, so far as expressing the rights and liability of party with regards to all or any of the matters in the suit. Decrees of three types: preliminary decree, final decree, partly preliminary, and partly final decree.
Under the Civil Procedure Code, the appeal lies from judgment or decree.
The appeal lies from decree, sir.
Whether the rejection of plaint is appealable.
Yes, sir. Rejection of plaint is appealable.
A person, a man, okay, gave assurance to B to marry her. In the pretext of that marriage, he has committed physical intercourse with B. Whether what offense he has committed.
He has committed offense under section 494 of the Indian Penal Code, which means with the promise to marry another person cohabits and has sexual intercourse with that person, and it is punishable under the Indian Penal Code.
Under which provisions of the Indian Penal Code only the death punishments have been prescribed? Only death punishment.
Sir, the different provisions where death punishments are only prescribed is Sir, I'm not sure. I think in case of, sorry, sir, I'm not able to recall, sir.
What is the evidentiary value of an FIR?
Evidentiary value of FIR, it is used both for contradiction and corroboration.
What is zero FIR?
Zero FIR means the FIR which is registered in a place than the place of occurrence of the crime. It is registered in a different place rather than the place where the crime has actually occurred.
What is complaint?
Complaint means it is an allegation made orally or in writing to a magistrate setting the grievances before the magistrate.
Can a victim be permitted to participate in a criminal trial?
Sorry, sir?
Can a victim be permitted to participate in a criminal trial?
Yes, a victim can be permitted to participate in a criminal trial.
What are the provisions relating to the participation of the victim in a criminal trial? The governing provisions?
Sorry, sir, I'm not able to recall now.
Under which provision of the CRPC the inherent power of Honorable High Court has been defined?
Section 482 of the CRPC describes the inherent power of the High Court.
What is an interlocutory order under CRPC?
Interlocutory order under CRPC means the interim order, the order which is given when the suit is pending and it is not decided.
What is an interpleader suit?
Interpleader suit means when there are two persons who claim money or any property from another person and another person has no interest in that property or money, only he claims for the charges of the suit, then the person can file an interpleader suit before the court to decide who is the rightful claimant of the particular money or the article. This is called interpleader suit.
What are the differences between judicial custody and police custody?
Judicial custody and police custody, it means the judicial custody means detention of the person in jail, and police custody means the detention of a person in the police custody, and police custody also means the place where police authority are there.
Can a magistrate direct the officer in charge of a police station to register an FIR?
Sir, magistrate can direct the officer in charge of a police station to register an FIR. Sir, I think magistrate cannot direct. I'm not sure about it, sir.
Okay. What are the differences between section 34 and 149 of IPC?
Section 34 describes about the common intention under the Indian Penal Code, and Section 149 describes about the common object under the Indian Penal Code. Common intention, here every person has to participate, has to make active involvement in the crime, then only they'll be liable for the common intention. But in case of common object, mere becoming the member of the unlawful assembly will amount to common object, although they are not involved, participated in the crime.
What are the rules of the procedure?
Sorry, sir.
What are the powers of an appellate court under the Code of Criminal Procedure?
The powers of appellant code under the criminal procedures are the High Court, in case of if the appeal lies to Chief Judicial Magistrate, then the Chief Judicial Magistrate can, in its appellate jurisdiction, convict the person, and it cannot be again if the chief judicial magistrate has convicted the person, then in the appellate jurisdiction, then again appeal cannot be made for confirmation reduction. Then if high court has given death penalty or life imprisonment in a particular case, then appeal can lie to Supreme Court, and Supreme Court can reverse the decision. Then, in case of if the session judge has awarded death penalty, then it is to be under by the confirmation of the High Court. Then only death sentence can be granted.
Whether the criminal court can review its own order?
Yes, criminal court can review its own order.
Under which provision?
Sorry, sir.
Okay, my learned sir will give you the feedback. Thereafter, I will give you the feedback. Okay?
Thank you, sir. Sir, namaskar.
Okay, namaskar.
Rutuparna,
Yes,
the
sir.
other day, I have specifically instructed you not to guess anything. Never
Yes.
say anything on guess. When you answer on guess, you commit mistake. Say, for example, you told that you answered that review is maintainable. Review can be made by the criminal procedure code. Where that is? You are answering that on guess. Second appeal never is there in the criminal procedure code, only in CPC. So never be guess. You are not, however, please say, everybody is not expected to know all the laws.
Yes, sir.
Never guess. Guess. By guessing something, you are endeavoring to answer all the questions. Probably you are on the, because may not be very polite lessons, I do not remember. I do not know. Thereby you commit mistake. Once a
Sorry, sir.
mistake is committed, mistake, not I will not, because it is I'm persuading you, and it is my duty to at least remind you, never guess.
Yes,
If
sir.
I guess, if I guess, I commit mistake. I
Yes,
do
sir.
not know what you know. Your knowledge, my knowledge, I know, nobody knows everything on this earth. Law is such a vast subject. Never guess. First, if, no, even 5 questions you answer, that's enough. Correct answers.
Yes, sir.
Guessing sometimes will create problem for you. Never guess. Again, I told you, as much as answer is required, give those that much of answer. My question was what? Be cautious. What is repetitive suit? A suit filed on behalf of many persons, behalf of certain persons, is called representative suit. When a person representing others, a group of persons, innumerable persons, files a suit, or a suit is filed against a person representing others, that is called representative suit. If my question was what is the procedure? Second, your answer will be the procedure as per order 1, rule 8, notice. If it notice should be someone should be given to all. If it is not possible, then that will be published in a widely circulated informing parties that they can join as party in this. Plaint is to be amended, not default, for just decision of the case.
Yes, sir.
An amendment is just decision because you told you need guess some defect is there because you made a guess.
Yes, sir.
Default. Everybody, because as a layman, you are guessing something, no, which is required for just decision of the case. Effective adjudication of the matter is dispute. Effective adjudication of materials are laid. Non-gender of necessary party. Necessary party, a party without whose absence in the suit, no effective decree can be passed. That is necessary. Proper party whose presence is necessary for proper adjudication of the matter. That is proper decision. Framing of additional issue, yes, you are correct. Additional issue can be framed. If there is an additional issue, one issue ought to have been framed, but that has not been framed inadvertently, the additional issue can be framed. Restriction on amending plate, a guideline is there once A particular time is there. Once a hearing has been completed, no fine, again amendment of pleading can be done. Already matter has been completed before delivering defense, etc. Injunction obtained unnecessary, you are also correct that for compensatory cost, that is cost you can file this, that person will file petition in that that unnecessarily injunction was obtained, that up to 50,000 rupees perhaps now it is there, that can be allowed, not exceeding the pecuniary jurisdiction of promissory note. Because in promissory note is an instrument in writing containing an unconditional undertaking to pay a certain sum of money only to a certain person. That is promissory note. Bill of exchange is a document containing an unconditional order signed by the maker directing a person to pay some money on his behalf to another. Bill of exchange. Check. Well, a bill of exchange is issued on a bank, that is called check. Right of private defense. Everybody has a right to defend his own body and the body of another and property of him and another when he is apprehending any commission of offense. That is called right of private defense. Yes, right of private defense is also available against any innocent person. Civil nature, on the other day, I have told you that civil nature, a civil suit, if a right to property or office is contested, is in dispute, that is a suit of civil. Right to property or office. Cause of action, your bundle of facts with the plaintiff will prove to get relief in the case. Counterclaim is made. The name itself, any claim of the defendant against the plaintiff in that is called counterclaim.
Yes, sir.
Set up in a money suit and ascertain some money maybe has to be set off from the claim of the from the money which has been claimed by the plaintiff. Suppose the plaintiff has claimed 20,000 rupees. Defendant claims that he is entitled to get 10,000 rupees from the plaintiff. That amount be set up. Then suit against government without notice, a case suit can be filed without dispensing notice for urgent relief. For urgent relief. Then
Yes, sir.
no relief will be granted in that suit without hearing the government, either interim or otherwise. Specific relief also, exact relief, which a person claims, that should come. Attachment before judgment is always in a money suit and for movable property. When the
Yes.
defendant is delaying the plaintiff, absconding, or they will do something to defeat the decree to be passed. So in such case, the court may issue warrant to bring the defendant and to furnish security for his activity. This is called attachment. Alternate forum also, arbitration, conciliation, mediation, that is section 89. UCC, UCC also you are correct, Uniform Civil Code will bring immunity and integrity of our country. There is a direction in directive principle of state policy. It is the responsibility of the state to implement it. So these are the things. You again you are saying giving lengthy answers. On the other day I had told you when you do not know any particular thing, never guess.
Yes, sir. Sorry, sir.
Thank you. Nice. So not sorry. I am reminding you to be careful. You are not committing any mistake. I am reminding your mistake so that you will not commit such a mistake in your interview. I want that you should be selected. This type of
Yes.
mistake should not be done. Very politely say, I do not remember, sir. This is
Yes, sir.
sometimes the judge says, I do not remember my lord. You may say, okay. Thank you.
Sir, namaskar. Yes, sir.
If you don't know the answer and you are not at all confident about the answer, and if the answer is not true, don't give that answer. Okay. And
Yes, sir.
besides that, where you have to, sometimes are there, so you have to look into the provisions. The answers which you are giving, Before that, you be sure that yes, I am telling the appropriate provision of the governing statute. If you are not sure, then don't say the wrong provision. Okay.
Yes, sir.
So during your session, came across with several provisions you have wrongly said. Okay, don't say that provisions if you are not 100% confident. If you are not sure that yes, that provision is true. Okay.
Yes, sir.
So in the meantime, just have a glance to a bare act, go through the provisions carefully. Okay, along
Yes,
with the definition clauses. Okay,
yes, sir.
and all the best and take care.
Thank you so much, sir.
Okay.
Rutuparna,
Yes, sir.
you go through the YouTube in one slot. CPC and evidence CRPC.
Yes, sir.
Some lectures are coming in one slot, just before that,
Yes, sir.
and also constitution. Yeah,
Yes,
as
sir.
far as possible, so that it will help you. It will help you in your interview. Thank you.
Thank you, sir.
Rituparna, you may leave now.